May it please the Court, Brown for the Secretary of State, Mr. Diller, King's Counsel, and Mr. Royston for the respondent. My Lord, my Ladies, I propose to structure the appeal as follows. First, introduction to the case. Second, legal framework. Third, submissions on the ground of appeal. My Lord, my Ladies, taking the facts then please from the chronology and the core bundle at tab 7. The Court will see the following facts and events. On 16th of February 2000, the respondent's date of birth. 16th of February 2020, the final eligibility date for child tax credit. One can receive that benefit until one's 20th birthday if in approved education. So from the 16th of February 2020, the respondent, Mr. Miah, is eligible in principle for universal credit if he chooses to claim that benefit. On the 16th of March 2020, a claim was made by telephone. On the 16th of April 2020, a decision was made to award universal credit. That was subsequently revised to add the LCWRA element. One sees the reasons for that at page 95 of the bundle, namely that it followed a medical examination. On the 23rd of July 2020, the respondent claimed that the benefit should have been paid from the 16th of February 2020.
Well, I'm sorry, because I was just in there sort of getting used to it. We are familiar with the facts. If there are particular points you want to draw to our attention, do, but you don't need to go through all that.
My Lord, I'm essentially there. Those are the core facts. The decision maker said no, and it's an appeal against that decision. So those are the basic facts, and then I'll turn directly then to the second of my 3 stages, which is the legal framework for the appeal.
Yes.
So if I can begin, please, with authorities. Tab 1, page 1.
Incidentally, I don't know who puts these bundles of authorities together. I think these days they tend to be done in chambers. Speaking for myself, I haven't asked my ladies, they may disagree with me, but I find it more helpful to have them printed as a PDF, as if they were looking actually at the statute as printed. These sort of HTML things are all over the place, rather.
Yes.
So could that be noted?
Yes.
My ladies aren't disagreeing, maybe not mine as much as I do.
Noted.
Okay.
For my own part, I will do my best, and thank you for that. So Section 1.1 of the Social Security Administration Act 1992, the 1992 Act, that, we say, establishes the principle that entitlement to benefit is dependent on a claim. So Section 1.1, except in such cases may be prescribed, ... no person should be entitled to any benefit unless ... A, he makes a claim for it in the manner and within the time prescribed in relation to that benefit by regulations under this part of this Act. That principle is discussed in Secretary of State for Work and Pensions and Nelligan, which is behind tab 16 of the authorities bundle. I'm not proposing to take the court to it unless it would be helpful. It encapsulates the principle, though, that there is no entitlement absent a claim. And we say that Section 1.1 of the 1992 Act is fundamental to the operation of social security in the United Kingdom, and in this case, it is based on what we've described in the skeleton argument as a principle of claimant autonomy, namely that social security is payable only if and when a claimant presents a claim. The state has no obligation to pay benefits for a claimant who, for whatever reason, does not present a claim. So one way of considering the issue in this appeal is essentially whether the temporal period is part of what must be claimed by the claimant. I'll develop that as I open the appeal. Staying with the statute, Section 5, please, is at page 5 of the bundle. Section 5 establishes the Davies for various regulations about claims for and payments of benefit as it's described in the heading to the section. I don't propose to read it out, but it's the Davies for the regulations that we'll come on to see in due course. And that's what I'm proposing to show the court from the 1992 Act. If I could ask you please to turn to tab 2 under the 1998 Act, the Social Security Act 1998. And the court has section 8. So decisions by Secretary of State, subject to the provisions of this chapter, it shall be for the Secretary of State to decide any claim for a relevant benefit. And 8.2. Where at any time a claim for a relevant benefit is decided by the Secretary of State, A, the claim shall not be regarded as subsisting after that date, and B, accordingly, the claimant shall not, without making a further claim, be entitled to the benefit on the basis of circumstances not obtaining at that time. And that encapsulates the principle then that up to determination, one has an extant claim. When there is determination of that claim, it becomes the decision on the claim. And insofar as there are different circumstances which might justify an additional claim, then those fall to be presented as part of a new claim. And that is of some relevance in this appeal. So saying that perhaps in another way, the benefit decision is based on circumstances existing at the time. If there are new circumstances, that requires a new claim. And our position, as I will develop, so when has one regard to section 1 of the 1992 Act, if there is no claim for the earlier period, then the circumstances for eligibility for benefit in respect of that early period do not exist. And therefore, if that claim is presented after determination, it falls to be treated as a new claim.
Well, I don't quite see how that fits in, but no doubt you'll, I mean, because this is a case where there's no dispute that the circumstances granting eligibility did exist before what you would describe as the claim date. So I'm not quite sure how 8.2 is relevant.
Depends how one uses circumstances here, because we say that circumstances forced to be read alongside section 1 is that if one wants to claim for an earlier date, then one has to claim for it. And that's part of the matters.
So I see the circumstances include the fact of a claim having been made.
Yeah.
I see.
And I'm not asking you to address it now, but at some point I'd be interested to know how the claimant on this particular form is able to claim for an earlier date.
Yes, I can address that now. So in the circumstances of this case, the claimant made the claim by telephone, and therefore it would be for the claimant verbally, through his mother, to identify the earlier period of the claim date. That is how it would be done on a telephone call application. That's not the standard process for universal credit. The standard process for universal credit is an electronic application made online. And in those circumstances, the system does not contain a question. This is something that's been identified in the judgment, as we'll see, and in the respondent's skeleton argument. There's no question saying what is the start date of your claim, but information can be volunteered and provided by individuals through something which is described as a journal, which the court will have seen in other cases, whereby one can put any additional information which is considered to be relevant.
So just
Well, at some point you'll need to talk us through that.
Yes.
That's very headline stuff. I'd like to know exactly how you can associate a journal entry with a claim, and so on.
Yes, C with documents.
Yes, well, I mean, we have a supplementary bundle
Yes.
which has 100 pages of
It does.
screenshots.
Yeah.
And I would like to be walked through. Well, in a sense, you don't need to walk through most of them because you're accepting that there is. But I still like to understand what the process is. If you say you want to deal with it now, let's deal with it now, or you want to come back to it later.
Yes. What I can say is that in those 100 pages, and this is part of the tribunal's decision, that there is not a question which says what is the start date of the claim. And that's identified as being a fact. That is the
I know,
percent.
but I still like to see exactly what you fill in.
I understand.
And in the context of that, it may make it easier to see whether it is realistic to say, and then you go and make a journal entry. I mean, you said it in very
yes.
headline terms.
I have,
You're assuming we know much more about this than certainly I do.
I'm not, and I apologise if that was the impression I gave. It is essentially that, though. It is simply inputting in the journal any information.
But what is the journal? How do you know it's there?
My lord, I will then address that in more detail.
Okay.
What I will say, though, is that technically that's irrelevant to the point of statutory interpretation. But I understand.
Well, it may or may not be. I understand that's your position, and indeed, to be fair, that's the position the Upper Tribunal took.
Yes.
But it is an oddity about this case that you're saying that the claim for, I know it's an inaccurate term, but it's a useful shorthand for backdating, can and should be made with the original claim. And yet there is no obvious means of doing so. And
Correct.
so we want to understand what your answer to that is, even if it's not strictly speaking relevant to the legal analysis, generate to your legal analysis.
Yes, I have no answer in the sense that it is right, as the tribunal has recorded, that there is not an obvious route, because the obvious route would be some form of direct question, perhaps.
Yep.
And that is not there. So if I were to walk the court through those 100 pages, one would see that it is.
Yes, I don't want to be walked through all 100 to prove a negative, but I would like just to understand. I'm sitting down in front of a screen. Yes. I've never made a universal credit claim before, or maybe I have, but I haven't made this kind of claim before. And what process do I go through?
Yes.
And I suspect I don't go through 100 screens, because if I choose one choice, you go straight to number 20, and it probably only go through half a dozen screens. But I'd still want to understand how it works.
Yes.
Normally we get a witness statement, but there isn't one in this case, is there?
No, because
the Upper Tribunal know all this. They don't need to have a witness statement to tell them.
They do. And if it were just on that very discrete point, query whether that could just be proven by.
Yeah, don't worry, I'm not making a formal point, but I'm just making sure I haven't missed something.
No, the court hasn't missed anything at all. What I'll just need to check is what I can best show the court in terms of showing you what a journal looks like.
Because, I did see there is a page towards the end of the journal, but
yeah,
look, I don't really want to take you off your course. We do all this later, but but let's just so you know what I would like. I'm speaking for my ladies, but aim off for the ignore for the moment the fact you say this strictly speaking isn't relevant anyway. I sit down in front of a screen. I want to make a claim for universal credit for myself or the case of my son, and I go through a number of questions. And we all agree that those questions don't give you the opportunity to say, and I want it for the last month as well as from now. But you say it doesn't end there, because you can still do that by a journal entry. Well, how do I find the journal entry? How do I find the journal? Who says if you want to add anything, that's what the journal is for?
Well, would it be helpful just to look at the journal now? We probably will.
If you like, yeah.
So it is a supplementary bundle.
Yeah.
103. So 102 to 103.
Sorry, what did you say? 102 to 103.
Does the court have a supplementary bundle?
I do,
yeah.
But I thought we were. Oh, I see. Yes, sorry. But this whole section starts at 23. But
yes.
Yeah,
so
yeah, got it. Journal. Yeah.
Yeah. So 102, 103. Report a change. You must tell us about any change to your circumstances when they happen. And then,
sorry. Wait.
Yeah.
This is a screen that comes up this is a page that comes up on the screen.
This is a page that will come up. This is what a claimant would see. Yes.
Page 103.
When you've submitted your claim.
Yeah.
Not having made a backdated claim, so you're not given an opportunity to.
Yeah.
Why don't you say, okay, I've done that, and go away and leave the screen? You think? How do you find your journal?
So if one's doing it entirely electronically, so not this individual who'd have to do all this over the telephone.
Yes,
If
no.
one's doing it entirely electronically, one logs in with the user details, and one sees a personalised page which shows you what your current claim is and other relevant information. So much like other online.
It shows you what your current claim. You're making a claim. You haven't made a claim yet.
No, but it'll identify what application, what claim is in.
Yeah. Okay. I know. We saw all that at the on page 24.
Yeah. So the journal which I had identified then, there's an example of this at 103, and one sees journal, use your journal to, then there's 3 bullet points. Add details about your work search, leave messages for universal credit, view your universal credit account history.
If you make a claim by telephone, as happened here, I think I read somewhere that the effect of that is that the person at the Department of Work and Pensions is actually just recording the information from the telephone onto a screen, so they're just filling in the form for you online.
Yes.
Is there ever a question to say, do you want to leave a message for your universal credit by way of journal entry?
I'll take instructions rather than answering on my feet. Having discussed this matter very carefully with my client, the position though is that there is a conversation and information can be volunteered, but the court's question is more specific. Are you specifically asked that question? I'll check rather than answering directly. The general process in terms of the telephone claims though is that it is designed to capture relevant information, including any information which is volunteered or provided by the claimant. Now, there's an extent or dispute as to the there's a dispute as to the extent into which that properly investigates all of the circumstances, leaving aside whether that is relevant. That is the process. So there's a conversation and it takes place orally.
Well, I'm assuming, again, we haven't got a witness statement here, but I'm assuming what one would expect is the person at the other end of the phone is effectively replicating the process that you would do if you had a computer in front of you.
Correct.
So they're basically starting on page 1. What do you want to make? What you want to do to make a claim? What do you want to make a claim for?
Yeah.
Then what's your name? All the best who you claim for? What kind of claim do you want to make? And so on.
Yes.
So effectively, they will be raising with you the questions that each screen raises.
Correct. Yeah.
That being so, if, as we've agreed, the screen doesn't say anything about, and as from what date do you want to make your claim, or do you want to backdate your claim, or whatever, however it will be worded, if there's no screen doing that, it's unlikely that the person walking you through it will do that.
Correct.
And we can infer from the facts here, can't we, that there was no question asked and no information volunteered, because the mother surely would have said, if anybody had said, by the way, you can backdate it for a month or you can extend the time backwards by up to a month, she would have said, oh yes, that would be good because his benefits got cut off in February.
On the facts of this case, no doubt that's what the mother would have said on the facts of this case. We don't know in other cases what they
In
would.
this case, if we just start little, it's always easier for me anyway to start with this case and then look at the other.
But,
my lady.
But we started. Sorry, we started on this process, so we may as well finish it. You were taking us to the journal.
Yes.
You haven't yet answered my question. Supposing I'm not familiar with the universal credit process, maybe I haven't made a claim before, or maybe I made a very simple claim and the money's just come in and I've never had to engage with the system. How do I know that there is a thing called journal and what it's for?
Because you'll see it when you go online, so you'll see your journal.
Well, will I? I mean,
yes.
Look at page 24. Select your area below for screenshots. I mean, they're slightly jargony. Well, the first thing I would expect to find there is on your account area is can I make a claim? But
yes, this isn't what you would see when you log in. So after you set up,
have we got what you see when you log in?
You see what is at page 105, not immediately. So you're asking for the court's asking for the home page when one logs in.
I see. If that's what it's
the
called.
home page is at page 100.
Yeah.
So apologies if I'm taking this too quickly.
No. This is the first thing you see when you log in. Sorry, I understood 24 was the first thing you saw when you logged in because it's called a walkthrough, so I naturally assumed that's what it was. But
yes. If I make minor errors on my feet, I apologise, but this is broadly speaking the process then. One logs in and sees a home page.
Yeah.
And that will allow you then, in what is designed to be a user-friendly fashion, to identify everything that one needs as part of the claims journey. So one will see then, for example, the ability to volunteer through
Well, I'm on
access.
page 100,
Yeah.
and I want to make a claim for, for universal credit.
Now you-
Which of these things would I click?
My lord has already made a claim for universal credit, so this is in circumstances where you set your claim up. So
I'm sorry,
I don't understand.
I don't, no,
apologise.
it shouldn't be this difficult.
my lord,
Imagine me sitting down in front of the screen. I want to make a claim. I've been told what the web address is.
yes.
So at least I've done that. I've got to SSWP Universal Credit. Hello.
I'm
What do you
assuming
want to do?
far too much.
Who are you?
Yes. We need to go all the way back to page 20, to where we started, to page 24, 25. So if the court wants to start the whole process,
Yeah.
right, I apologise. I thought we'd already set up an account. So one needs to set up the account in the first place.
Well,
So-
just be clear about this.
Yeah.
That I agree. I might have to do that. In the present case, there is an account already, but it's for a different kind of benefit, which is now stopped. So I've got a claim for a different kind of benefit.
Yes.
So I imagine there was already an account for Mr. Miah.
Well, was that a digital account? I don't think it would have been for a child tax credit, but I can take instructions on that.
Okay.
This is a new bespoke system, which requires then one to set up a new.
Yes, I agree. Of course, I appreciate this is a telephone thing, but
Yeah.
but in the great majority of cases it won't be. So
Yeah.
we can forget about Mr. Miah. Let's suppose the absolutely basic situation: you've never claimed universal credit before, so you have to set up an account.
Yes.
Yep.
Page 25 then. So you have found your way onto the page, which is to
Page
set up universal credit online.
Yeah.
So I'm assuming that the
Yep, got that.
claimant has got that far.
Yeah.
Okay. So the claimant then presses the start button
Yeah.
online, or they sign in if they have already got the
Yeah.
universal credit.
Okay, it's all making more sense now. Yeah.
Okay. Right. Then
You have to claim online if you want universal credit. That's the only portal.
leave
By
this aside.
telephone or,
Yeah.
or this one.
Indeed. Yes. It's an online system, so digital architecture.
It's 80%, isn't it, in the order of claims? 80% online, 20% otherwise.
Not the-
Miah.
Yeah, I thought it was more like 90,
95.
98, yeah.
Yeah.
Um,
That is in the judgment somewhere.
Yeah.
But
it is.
so anyway, most people are doing it this way.
Yes. So
And
So the first process is process is most cumbersome because you've got to go through all of the questions before one then establishes the claim. So that's what one sees from page 26 onwards. Are you getting any disability benefits? Do you have that at page 26, my lord?
yeah.
And then
So you say no, or maybe yes, but
yeah, as the case may be.
As the case may be.
Your partner,
So these are all the gateway questions.
yeah. SDP
Mhm.
28.
Got username and password. Well, of course, if you're starting, you'll have to set up a username and password, but that
Yes.
bit's been left out. Yeah.
Yeah,
And you sign into your account.
yeah.
Is that right? I thought. Anyway, okay.
We'll assume that one
Yeah.
does sign in.
And you confirm it's you. Yeah, they're a bit all over the places, but some of them are about creating an account and some of them are about signing in. But we didn't quite either you have got an account or you create one.
Yeah.
And at what point do you come to actually doing something?
Well, you've already answered some of the questions about eligibility. So,
Have you? Where was that?
well, so for example, SDP is a question about eligibility because your answer to that will impact on your eligibility for
So
you.
why are you doing that so early in the process before you've even said who you are?
Well, that is likely to be because of the rule that meant that you couldn't claim universal credit if you were in receipt of SDP.
I thought this was because there was something special about severe disability premium. That
Yes.
it was okay, but that
This is the point I just made that if you were claiming it, there was a what was described as a gateway, but a block.
And there might be a special, okay, but isn't that a bit of a red herring, isn't it? For the,
Yes.
but normal, well, let's assume you aren't someone with severe disability premium. You said no to all that.
Yep.
So up to that point, you said nothing about what you want.
Well, you want universal credit, as it were, but what you have to then do is establish the basis of your entitlement for universal credit by reference to your qualifying criteria, i.e. your personal circumstances, and then things such as your
Yes,
needs.
but we haven't had any questions about that
No.
yet.
Okay, so questions then on page 42. Relationships and claims as a single person, because there's a principle of universal credit that
Yeah, so this is claim partner and so on.
if you're a household, you claim as a household, for example.
So does the real meat start at 45? Is that what a to-do list means? They want to discover.
That's all the information you need, isn't it? The qualifying information.
Yeah, that's right. So that
So
is
they ask.
Tell me if I'm getting anything wrong.
They ask, are you in educational training? Right. Then they ask, have you got any savings?
Yeah.
Then they ask, have you got any income other than earnings? Then they ask, what nationality are you? Then they ask your bank details. Yes, I see, carer. So really, you don't ask for anything. They just take all this information and they say, on this information, the computer says you're entitled to this element of universal credit.
Correct.
Right.
I think 89 might be significant because there's all this stuff about the details, and then you get to the legal declaration, and you'll tell me if I've got this wrong, but it looks to me like you tick the box saying I understand and agree, and then you say submit claim, and that is the date of your claim.
Correct. Yep.
Automated. There's nothing here saying is the date going to be anything different. It's just it's the claim happens on the date you press submit claim.
Yes, that is correct. And then one has done that. One has then an extant claim. So
and what you can, just to be fair to you, what you can see is up at the top of that page a journal. So if you were full of enthusiasm to say, but I know I'm submitting my claim on the 16th of March, but I think it should have started on the 13th of February.
one could do it.
It might exist there to be able to click on.
Yes, I see. I hadn't realised that little. I didn't spotted that at all. But my lady's more.
I think that's probably.
So that you can click on that, and that will take you to, if you know there is such a thing as a journal.
Yes, well, you will learn as part of the process, but because you.
At what point will someone tell you if you've got additional information or things you need to use a journal for? This is what a journal is, and how do you use it?
Well, if one finishes the application and submits, as my lady has just said, and provides all your proof of eligibility and done your quality questions, etc., then one then.
Sorry, this is very basic stuff, but unless we go through it, you're just going to find you assume we know things when we don't. So the model of this is you don't identify a particular element in universal credit to which you think you are entitled. You just say, here I am, I have this income, I have these characteristics. What am I entitled to? I'm entitled to something, I believe.
Yeah.
You please tell me what I'm entitled to.
Yes.
That's the model.
The digital infrastructure, i.e. the computer, will then compute.
Having all these things you've done in your to-do,
Yeah.
the computer will come up with the answer. You're entitled just to the basic element of universal credit, or entitled to universal credit plus this or that.
Correct.
Yeah, got it.
So no human interaction in the ordinary course, because this is where the efficiency of this.
Yes, okay. Well, as my lady has quite clearly identified, at 89, that's the moment at which you submit your claim. You have the opportunity then to click on the journal, whether presumably before you've submitted your claims. Once you submit your claim, this page disappears.
Yes, however, we said it doesn't matter if it's before or after.
No, I understand that, but I'm just talking about how the real person could, theoretically, a person say, well, I want to submit my claim, but I noticed there was that box marked journal.
Mm-hmm.
I think there's more I ought to tell them. I'll come back and do that later.
Let me just take instructions as to that very specific question, namely, can one access the journal prior to submitting the claim? Because I don't know off the top of my head, and I'd like just to be clear from those
CPAG people say no, shaking their heads, but
the
your people may say.
They may say no as well, and it may be that the journal only appears on your screen immediately after
Well, does it appear immediately after? That's the next
Well,
question.
okay, well, that's the next question.
It says
The journal doesn't disappear. It's there.
Yeah, tell me.
Sorry. The journal is there.
Before the claim. We'll try and get to the bottom of that.
Before this, maybe
That's what it says on the form.
Right, thank you.
Do you know, Mr. Brown, it does strike me that if a number of people in this court are grappling with this and not getting clear answers, what about the applicant who is doing this for the first time and attempting to navigate their way through this?
Yes.
Not the easiest of processes.
Well, my lady fairly identifies that. However, simplicity in scheme design is intended to be integral to this system. Now, what is difficult for me to explain by reference to printed pages is what, in fact, how that experience exists for the individual before a computer. But compared to the system that it is replaced, it is considered to be.
No, speaking for myself, I've done universal credit cases, and I'm pretty impressed. I know there have been incredible teething problems, but over the years, it's clearly got an easier and easier system to use.
Yes.
So you may have to persuade my ladies maybe more sceptical than me, and perhaps that side of the room maybe more. I don't think I have no reason to believe it's a bad system, but this is a particular problem.
Yes.
And we do need to understand how it works for somebody. They've done all this bit, they found it fine, but we and had no difficulty filling it in. And however, it hasn't occurred to them that there's a question about backdating. It hasn't been raised with them. You're saying, never mind, they can add that information in the journal.
Yes.
And what I want to understand is how they know that that is a journal and what it's for,
Yes.
whether it presents itself to them automatically once they've made the claim. Is the next page journal saying, do you want to add anything? I suspect the answer is no, but this is the sort of thing I just want to understand.
I understand entirely. And obviously we are here in the Court of Appeal because we have a particular issue, a particular complexity in the case which we're looking to deal with. And so the claim generally and the system generally works incredibly well, it is considered to. We're dealing with a very, very narrow
Well, all right, but Mr. Brown, you're not doing an advert for Universal Credit. Let's assume it's a really good system and it works really well,
Yes.
but we've got a particular problem. We want to know how it copes with this problem.
Indeed. So
Your submission, I think, is that it's mandatory that the person who's got as far as page 89 digitally or on the phone, at that point, if they do want to backdate their claim at all, they must go into the journal and they must signify that because there is no other way that they can do it. They have to do it that way.
if they are only using an online system, so there are other routes in terms of going to a job centre and speaking to a system, but leaving all of that to one side.
Thank you.
I've got online or
It's
telephone.
relevant.
I've got online or telephone in my mind.
You haven't mentioned a job centre at all up to now.
Well, no, because I can. At the moment, I'm focusing on the digital.
No,
system.
no, you don't, no. You have said, and well, there isn't any evidence, but the Upper Tribunal has said, or maybe it's in the skeletons, there are only two ways of claiming.
Claiming, yes.
Yes.
So the factual footing for this appeal, it is absolutely clear that there is not, as it were, a question in the.
I know.
Yes. So what is?
We're suddenly talking about the job centre, and that just confused me.
I apologise. In terms then of the pure digital system, is there a route there? Answer: yes, it is the journal.
But how do you know the route is there?
Because when one then logs in after having set the claim up, you don't see all these questions about eligibility. You go then on to.
But why would you log in afterwards? You've made your claim.
Yes.
Why would you log in again?
Well, if one looks at page 100.
Yeah.
These are some of the reasons why you may choose to log in. Report a change of circumstance, report a fit note, add a note to your journal, apply for an advance payment, view your to-do list, look at your commitments, report your childcare costs.
Yeah, I see all that, but you might think,
So
I filled in the claim already. I've got no reason to believe I've done anything wrong. I know I've been told the money will come through in a month.
Yeah.
That's it.
Yeah.
I've got nothing more to do. Why would I log in again?
You wouldn't.
No, exactly. So how would you ever get? how do you get to the journal to make your entry?
You log in.
Yes, but why would you log in?
Because you wish to add some information to your claim.
Yes, but how do you know you ought to add some information to your claim?
Because you are identifying the fact that you wish to claim for an earlier period, and that is the only way to do it.
Yes, so really what you're saying is, if at the end of all this process, you thought, well, I've done all that, I've made my claim, but there wasn't anything actually asking me if I wanted to backdate it. Now, how do I do that? And maybe because you're very intelligent, or because you go to the job centre and you ask someone there, they say, oh, well, you better put that on a journal entry.
Yes.
Then you go, but the system doesn't prompt you to do that. No, okay. Well, I think we've got
even
that.
when you get to the home page, you have to understand that backdating your claim is something that comes within the umbrella term of adding a note to your journal.
Yes.
And if you don't add a note to your journal before the claim is determined, on your case, you're out of time.
Yep.
Yeah, I see. And that's what it would be. It wouldn't be reported change, because it isn't a change of circumstances. It's something that's always been the case.
No, because you're, depends what you mean by the case. You might have been eligible,
Yeah.
but you're not eligible unless you have claimed. So you might have been
Yeah, but no lay person looking at this would think it was a change of circumstances, that the change of circumstances consists in the fact that I am now wanting to backdate it. I always actually wanted to backdate it, but I just wasn't given an opportunity to do so.
Well, in which case,
I wouldn't regard that as a change of circumstances.
No, maybe
it's
maybe
more add a note.
it's more add a note, yes, I
Yeah,
agree.
okay.
So the tone is very much add a note. In other words, any further information you think we ought to have.
Yes.
But when you put it in the context of this case,
Yeah.
actually it's a mandatory requirement if you want to backdate, is that you have to give the early date by way of note on the journal through page 100.
Yes, and we say that this system is in fact the same as legacy systems in the sense that if you want to claim for a different period, then you have to volunteer that expressly or
But
impliedly.
it would be a lot easier on legacy systems were paper-based.
Yeah.
We haven't been shown the paperwork, but I'm very often on a form as is anything else we ought to know.
Yeah.
And even if there isn't, you just write it in a box anyway.
Yeah.
So in the box that seems least unsuitable.
The free text box would capture that. I agree with that. That is certainly right. The journal is a free text box. It allows you to add any information that you want.
Yeah. And so probably what you would do is looking at 103, you probably go to the second bullet. I don't know whether, are these all hyperlinked? You
Yes.
click on, so you hyperlink on leave message. So you leave a message, and the message would be, I've just made a claim.
Yeah.
Well, I made a claim 3 weeks ago, but anyway, I've made a claim which is still extant. I didn't say I wanted to backdate it because this form didn't let me, but I'm telling you now.
Yes.
Yes, I see. Okay. Thank you. Well, it took us a long time to get there.
No.
But that's how you say it has to be done. And the weakness, just so that you know in that, is that unless you are well advised and thoughtful about it, there is no prompt to consider whether you want to backdate or whether you want to start from a date earlier than the one of the claim.
Yes.
And even if the thought crosses your mind, there's no way of telling you how to do so. You would just have to ask someone or think, I wonder whether this journal thing will be a way of doing it.
Indeed,
Okay.
yes. So
It is a weakness in the system, isn't it?
room for improvement. Yes.
But this digital system has been here for quite a long time, hasn't it?
Yes.
And the issue of backdating has been around since the early days of the system. This has never been a problem up to now.
Yes.
Well, there we are.
Well, it depends what one means by hasn't been a problem. There have been cases on it, so in a sense it has. But
I didn't think that. Oh yes, we know there have been some cases. We haven't been shown them all,
No.
but one of the reasons why this was set up as a 3-judge tribunal
yes.
was precisely because this had been coming up a bit, and different FTTs have been reaching different decisions.
Yes.
Yes, I see.
That is right. I mean, so the court will have my submission. Room for improvement is not the same as illegality. In this case, in particular, in circumstances where this is not a public law challenge as such, this is not
No.
about irrationality of scheme design. This is purely
Purely a point about construction.
Yeah.
The most, Mr. Lemay may say something different, the most he can do about this is in a general background way say, if you've got 2 possible constructions, you should adopt the construction which fits in better with the procedures as they are now, rather than having to change.
Yes.
I can see even that might be thought to be intellectually impure.
It depends what one means by the procedures in that sense. So if the procedure is such that there should properly be that question asked, then all that the respondent can say is that your technology is not asking that question. But that is not the same as, I mean, that can't tell you anything about what the meaning of the statute is.
No, and as you said, as I made this point already, the Upper Tribunal themselves took the purist view that actually the fact the system is defective, if this is your construction, is neither here nor there. It just means you better change it.
Yes.
Yeah.
Um,
Okay, well, thank you. We got onto this because my lady asked a question which was in all our minds, but we've rather taken you off your course.
No, it is the obvious first question. I understand that, and I hope that's been addressed. I have asked for the specific printouts for the individual claimant for his application to be brought to court because they weren't in the bundle. I don't think they're going to tell you anything that you've.
Well, because they will actually not have been done by him or his mother. They will actually have been done by the civil servant at the other end of the phone.
So we printed them off on
well,
the
that
system.
would be useful to see.
Yes. Okay. Well, we'll have those handed
Thank you.
and circulated. They're not a thick amount of material. It's just I think headline points which just identify what's
Fine. Well, we'll look at them when they come in. If we have any questions, we'll ask you.
Yeah.
Right. So we were going right back. I'm not sure you'd even reached Regulation 26 yet, had you?
No.
You were on section 8, and yes, I don't know if you were going to go to section 9.
Yeah, so section 9 then, revisions.
This is a provision that I think Mr. de la Mare places some reliance on, but I don't think it was mentioned by the Upper Tribunal, and I'm not sure I know your answer to it. Why doesn't this apply in our case?
So revise within the prescribed period. Make a decision. The Secretary need not consider any issue that is not raised by the application, as case may be did not cause impact on his own initiative. I'm just going to have to remind myself what Mr. de la Mare says about this.
I think, well, I don't want to put his case, and I don't want to take you out of sequence. I don't want to make his case for him. But as if we were on the 1998 Act, I understood him to be saying, once the decision is made, it becomes subject to section 9, and you can apply for the decision to be revised. So he says Regulation 30 is neither here nor there, because that just means you can't amend your claim. But so what? Because you've got a decision that you can review instead.
Revise.
I'm sure you'll put it greatly more elegantly than I've just done, but while we're with section 9, it would be helpful to have the answer.
Let me just come back to the court on that in terms of the chronology, in terms of how that fits in, if I may. I will come back to it. Let me just go through the entirety of the...
Yep, surely.
So I was proposing then to go to the regulation, so Regulation 26.
Yeah.
So Regulation 26 at page 89. Time within which a claim for universal credit is to be made. So this is about the timing of the claim. So the basic principle remains section 1 of the 1992 Act. So 26.1, subject to the following provisions of this regulation, claim for universal credit must be made on the first day of the period in respect of which the claim is made. And 2, where the claim for universal credit is not made within the time specified in paragraph 1, Secretary of State is to extend the time for claiming it subject to a maximum
Well,
extension.
we've read this, yes. What's the point you're making?
I'm
What do you want us to
showing
draw from this?
the regulations. So I'll make my submissions as to how it all interacts in a moment. So this is just identifying it.
Yes.
So identifying then Regulation 30 at page 95, which the court will have seen. So amendment before a determination.
Just remind me, which was the circumstance that would have applied in this case had an application been made?
3B.
Yeah, so the claimant claims disability, so he would fall within 26(3)(e).
Yes, so that would have been a problem. So it would really all have been on 2B.
So there is no dispute in this case that if the mother had said on the, whenever it was, the 16th of March, by the way, I think I want to backdate 16th of February, that would have been entitled to that.
Absolutely, yeah. Well, subject to obviously to the determination of the factual matters, but that would be
Of
valid.
course, that's what's been remitted, isn't it? Is whether the facts were met here.
Yes, I tell you what puzzled me. I've got it now. If we look at your skeleton argument, paragraph 8, it's page 4 in the bundle. The version of 26(3) that we've got here is different from the one that's in the authorities bundle, because there's a double A. Rather oddly with a square bracket after it, but no, as far as I can see,
Yes,
no.
it is. Well, there was an amendment in June of this year.
Well, which is the version we ought to be which is the right one?
The authentic one for our purposes is one in the bundle, so that's the one at the relevant
So
time.
don't worry, I'm not putting the boot in. I just
Yeah.
but I just want to make quite sure. You have put the wrong version in your skeleton.
Yes, I think I put the current version in.
Okay, I'm not trying to be nasty
No.
to you. I just want to make sure so I can cross that out. Because I rather guessed, but wrongly, that was the one that applied here. Okay, so it's B, the claimant has a disability.
Yes.
Yeah.
So broadly speaking, in answer to my lady's question, then, had the mother said, I want to backdate, that would be very clear. So that would be an express request for backdating. And
Yeah.
that would
And then if, as long as it was established on the evidence that the claimant for whom she was claiming had a disability, that would be a sub-regulation 3 circumstance, so that he would have had his backdating.
Well, it would also be necessary, wouldn't it, then to look at B to
Yeah,
see whether, as a result of the disability, the claimant couldn't have been expected to make the claim earlier.
Yes,
Correct.
now,
So
you're right.
there's a causation point as well. So that
But so again, just going back to our earlier discussion, if it had been done by the way in which you say it could have been done, by a journal entry, the journal entry would have to say, I want to backdate for 1 month because I've been eligible for at least a month. I have a disability, or the person for whom I'm applying has a disability, and because of the disability, we couldn't reasonably have applied a month earlier.
it would need to have.
That would have to have. You know, you wouldn't have to write an essay about it, but they'd have to explain why the disability prevented them from doing so. That's how you say the system's supposed to work.
We wouldn't go that far because we would accept, and this is the next point I'm going to make, that one has to then place this in the context of the inquisitorial function of Social Security, namely that if there is sufficient material there to invoke the jurisdiction to backdate, then that will be something which the decision maker should properly then investigate to a.
So how would they do that? Perhaps, sorry, this is the point you're about to make, so you don't mind doing that. How, a decision maker, how do they investigate? Do they ring up?
Yeah, they just ask them, or what they do digitally. So when you say X, Y, Z, please can you provide more information? And if that then is effectively,
And that's normally done. That's normally done by a phone call, is it? Because you've given your mobile number, or you also given an email address if you have one.
it would normally be done online actually. So normally the response to the journal entry would be an online message in response to the message.
And how would you know you've dropped such a message? It would click up in your inbox, would it?
Yes, you'd be alerted, yeah.
Yes, I see.
So we would accept then that it doesn't need to be an essay as the court puts it, but the claimant does not need to say, I have a disability, this is the precise date I wanted to claim from.
That would really be enough. And then the onus will be on the Secretary of State to say, okay, I see you have a disability, but why wasn't, the obvious question would be the 2B question. You know, you say you can't, no matter what the disability is just to make one up. You know, I can't walk. Why is that relevant to not having been able to make the claim?
Yeah.
Yeah.
And
Okay.
the short point between us is that we say that the claimant has to do something to invoke the jurisdiction
Yeah.
in 26.
Okay, I've got it. Yeah. Right. Thank you.
Because the
So when I have to say, and I've got it, I haven't actually. I think I was about to write down no issue that if she had made a claim in time, she would have had it. That's actually not right,
well, subject to
because
the,
it still needs to be investigated.
Yeah.
The answer might be very straightforward, but it hasn't yet been fully
the
investigated.
pure point, the reason why we're before this court, is that the effect of the tribunal's decision is that you don't need to say anything at all.
Yeah.
And we say that can't be right,
Yeah.
irrespective of the stage you're doing it. So if it's revision or whether it's the original claim, it can't be that you're just completely silent and then you come along and then say later, post-decision.
But that's the point. That's really the point of this case, because the mother did say something, but she didn't say anything until after she got the decision and realised that it was only starting in the middle of March, and she thought her son's benefits had stopped earlier in February, and she wanted to investigate at that point backdating. So that was her date of knowledge that there was a problem.
Yes.
She didn't realise before then that there was an issue about when it was going to start. Maybe she hadn't addressed her mind to it.
Yes.
So this is a timing case. This is about the time at which you raise your hand and you say, I want to backdate.
Fundamentally, because it goes to jurisdiction under the statute. Yeah.
But it's not quite as simple as that, is it? I mean, Mr. Delamere may be putting his case a particular way, which we'll look at in a minute, but the result of the Upper Tribunal decision is quite apart from the point my lady's made, that you have to backdate even if a claim hasn't been made at all, as long as there's eligibility.
It is possible that it goes that far, and it's only argued in that way below, namely that you're effectively under some sort of duty to maximise the claim.
Yes.
Which we say can't be right if one has regard to the section 1 and the principle of autonomy, namely that you are only entitled to a claim when you establish what you're claiming for.
But I mean, there's two battlegrounds. There's one, what do you have to do when you claim?
Yeah.
And there's the second battleground, what happens if you claim late after a decision has been made, which is what happened here.
Yes.
And your answer is, well, I'm afraid that is too late because of Regulation 30.
Yeah.
But I think that's going to be challenged.
Yeah. But
But so I mean, I see why my lady said that that's the real battle, but in fact it's two battles.
There are.
Yeah.
Well, I agree. So in terms of where we sit on the, let's just use the metaphor of a battlefield because it isn't.
It's only a forensic battlefield.
Yeah.
And it's entirely,
Yeah.
obviously friendly in every other way.
So what we say then, I'll make my points by reference to Regulation 26 and 30, is that you can't then amend after your determination to volunteer new parts of a claim after determination. So if the circumstances exist, they can be supplemented. So if in fact you said a claimant is relying on disability, they can provide more information in relation to their disability, which might then support the causation argument, i.e. the reason why they didn't claim in time. So that can be done.
I haven't quite got. You can't amend after your determination to make new parts of a claim.
Correct.
I've lost sight of whichever provision it is that talks about making a new claim. Is it 8, section 8?
Yes.
Section 8.2. Is that what you rely on?
Yes.
Where at any time the claim is decided and doesn't subsist after that time, the claimant shall not, without making a further claim, be entitled to the benefit that's been claimed on the basis of circumstances not obtaining at that time.
Yeah. That's
where you get into either you have to make a further claim once the claim has been determined, and you're not allowed to raise different circumstances. Is that right?
You're not allowed to have different parts of a claim, so you can't say, well, actually, I'm also claiming for these additional benefits. Now, this doesn't really apply under universal credit as such because it's just one comprehensive benefit. But we would say that you can't say, actually, the temporal duration of my claim starts 2 weeks earlier. That is a new claim. So if, in fact, your position was, I claim on the 15th of February, and then you decide later, I actually now claim on the 1st of February, that's an additional 2 weeks of benefit. That is a new claim which requires a fresh claim, because under Section 1,
You'll be out of time to make that, won't you, because of the way it works?
you may or you may not, depends on how you do it and when you do it. If you do it the day after your claim and say, I
You'll be
claimed,
within time, yeah.
yeah, you'll be within time. So,
Because your claim will, by regulation 26(1),
yeah,
will be the date on which your claim will be dated the day on which the first day of your claim. That all conflicts
Yes.
into one date.
correct.
And then you'd say Reg 26(2) would potentially permit you to go back by a month. So you've got a window of a month to go backwards.
Yeah,
But you could miss, if you missed that, you missed it.
if you missed that, you
That's your
missed
fresh
it,
claim
yes,
on.
yeah. And subject, just to remind myself from precisely how it's been in skeleton argument, that's what we say on revisions, because they're the same claims. So a revision of a claim is a revision by reference to the claim as originally presented. So,
You have amended claims and revised decisions.
yeah, revised decisions.
We haven't, I think, yet gone to the provisions about revision, have we?
Only Section 9, very briefly.
Well, that was Section 9, but no, well, that was I'm not quite sure this is the same thing, but as I understand Mr. Delamar's skeleton, which I've just been doing out again, the bit about revision is at paragraph 16, page 15 of the bundle, and that refers to regulations 5 and 6, which I don't think are ones you took us to. If you did, I wasn't listening. I apologise. So that would be where are the
Yes, so
Tab 7.
tab 7?
They're not in the bundle because there's no dispute about the time limits for revisions. So revisions have their own time limits. There's a time limit within which.
Why aren't they in the bundle? I thought they were central to your case.
No, with respect, they're not because there's
Oh,
no,
I see. Well, I may
there's-
have misunderstood.
There's no dispute that the application for a revision made by Mr. Miah was tenuous. So there's no dispute that they complied with particular time limits for
I'm-
revision.
You said there's no dispute. It's entirely my fault. I hadn't really focused on this until very recently. But I thought, I don't see any reference to the revising power in the decision of the FTT or the UT. It came in the first time, I think, in your skeleton.
That's because, as we understand it, the dispute over revision is indeed in relation to the exercisability of the power to revise. In
Perhaps
Section 9. And that's because
No, I think we stop for a moment, Mr. Lemon. I think perhaps we should wait for you to make your submissions.
Of course.
But the fact is that we haven't got the provisions about revising in the bundle.
We'll supply them. I'm very sorry they're not in
Yeah,
the
but it's 1 month from the date of decision or a backstop with permission of 13 months, is that right?
Absolutely.
This mother's claim went in within a month of the
Exactly.
decision. So that's why you say, for this case,
Exactly.
it's okay.
Exactly, my lady.
Yeah, certainly my position was I didn't understand there to be an independent point on revisions because the logic of the argument has always been that essentially the issue is the extent to which the backdating issue, just to use a shorthand, needs to be part of the claim, i.e. the original claim, which is the claim which may or may not be revised. We say it needs to be
Amended, let's get the language right. You amend a claim and you revise a decision.
yeah,
Can we just
yes.
stick with that?
I apologise. So
Simple
I elided the two things. So the amended pre-decision, then decision revised, so post-decision. My lady's absolutely right about that. The principal issue is the extent to which backdating falls to be part of the matters presented as part of the claims.
I think, as just working through
Yeah.
section 8, the reality is unless you do the journal entry that we've just looked at, when you make the claim or very shortly after making the claim, you can't backdate because the moment the claim is decided, all you can do is make a further claim, section 8, subsection 2, and you're almost bound to be out of time.
Yeah, so that is the practical consequence of the timing and the 1 month universal credit decision cycle.
You've got to mention it at the time you make your claim.
Yeah.
Or shortly thereafter.
Or shortly thereafter, before it's determined.
Effectively within the next, because the Secretary say ought to determine within a month.
Yes.
And so you really need to do it within that month or earlier still in case he's particularly prompt.
Yeah.
But I was going to use a different word, but you're stuffed. If you get the decision first, you wait for the decision, and then you could go, oh gosh, it's got the wrong date on it. You're out. In
Right.
reality, you're out.
Yeah, that's precisely how it works. That's how it worked in this
Yeah,
case.
and so, but I just wanted, you say, the reason why you say that any point that may be big to be made, we'll have to wait and see about revision, is a red herring. Is the revision is simply of a decision relating to the claim as made.
Yeah.
And by definition, it's a claim which, if you're right on your first point, hasn't been a claim in relation to an earlier period.
Yes, that is the true nub of the appeal in my submission.
Because I think Mr. de la Mare is going to run something on this, but we'll wait and see how he puts it.
Yes, I mean,
There isn't a respondent's notice, but we'll see about that too.
Well, I'll listen, but I don't see anything in the very short statement of principle and skeleton argument which suggests there's some different approach to revisions after the decision. But
Well, there's something somewhere about how once you get to an appeal, it's a full hearing. I'm looking at paragraph
Well,
35.
let me address that then.
No, well, let's wait and allow Mr. de la Mare when we get there. No, not now, Mr. de la Mare, to make his submissions.
There's no such case.
I'm told there's no such case. That's fine.
Appeal is a rehearing of the application and the decision.
Yes. Let's. It's a mistake to try and speculate. I may have read too much in just looking again at the slide. I hadn't really picked this point up first time round, but I was just looking at it again.
I think that is we'll see.
Okay.
Let me say, if I may, what we say, and I apologise for repeating it, but I'll just say it as I prepared it so it's clear. So one makes the claim, one cannot amend the claim after determination.
Yeah.
So if one has not then claimed for the backdated period or the earlier period, that is the end of the matter as far as that decision goes. So what the Secretary of State can do thereafter on a revision is to reevaluate what the original terms of the claim indicate about what the period for which the claimant was asking for benefit. But what they cannot...
So evaluate entitlement within the period, in other words, from the date of claim onwards.
Well, they can look at the material that the claimant has presented, because one can have for example, what if a claimant has in fact volunteered all of the information, but the Secretary of State has not decided the backdating question, then the decision can be revised because the claimant has plainly asked for it, but the decision has not been reached correctly.
But revision isn't only about backdating. It can
No.
be about anything in
Correct.
which the computer, because it normally will be the computer, has made a wrong decision on the basis of the information supplied.
That's the critical part.
Yes.
So there's no facility for any further information to come in at the review stage that might cast a different light. So if somebody had left out a medical report, or
Revision.
something like that.
Revision.
Well,
Sorry, revision, was I using the wrong language?
That is fine, medical report, because that goes to the existing circumstance of disability, for example. So if the claimant is saying, I have a disability, decision maker says, oh, I don't accept that. Claimant can amplify that with more information which supports the disability question, because they're asserting disability.
Yeah.
But that is different conceptually from a claimant who has not
So
said.
is this?
The review does not let you, the proposition is a review does not let you look to the date point, doesn't allow you to go as far as backdating.
It does not allow you to add a new retrospective component to your claim.
Yeah.
That's how we would put it.
Can you just tell me where I get that from? Which bit of statute do I look at?
It's the interaction. So one starts with Section 1, and we say Section 1 is critical. So Section 1 of the 1992 Act, the principle that you only get what you claim for. So if you have not claimed for cash from a particular period, you are not entitled to it. Section 1 applied.
Yeah.
That's a fundamental principle.
Yeah.
If you have, then Regulation 26 is governing the way in which the claim is made. So the starting point, 26.1,
Yeah.
is that you're taken as having claimed from the first day of the period.
Mhm.
That's 26.1. However, if in fact you present a claim for an earlier period by reference to Section 1, then you need to justify why you didn't present it on the earlier date by reference to the exceptions, or not the exceptions, the reasons and then the causation argument.
In 26.2.
Yeah, so that's how you justify your Section 1 claim for earlier benefit. And you say, I couldn't have claimed earlier because I had a disability and I was incapacitated. In which case, Section 1 is satisfied, you've got your claim for your earlier period.
Yeah.
The 26 is only about mechanics. It's Section 1 which establishes the foundation principle that unless you've actually identified do you want that money, you're not entitled to it.
That might deal with my lord's first issue, which is you've got to make a claim.
Yeah.
It doesn't really deal with the second issue, does it? Which is the out of time claim, or what you'd say was an out of time claim. So a claim that comes in a bit later after a decision's been made.
Well,
Why is that knocked out of the review process?
30 is the answer to that then. So what the system is doing here then is ensuring there is finality in the process. And it allows you then to amend your claim for such period as it remains under consideration, which will be, generally speaking, a 1 month period. And then that's it.
We're on revisions.
Yeah,
On
but
revisions.
the
And
revision
my question
is-
to you is why does the power of revision necessarily extend only to the evidence that was before the decision maker at the point the claim was made, and why can't it include some after acquired evidence? And you said it could include a medical report, but it couldn't go to backdating.
Yes, so there's a difference. Yeah, there's a difference between the evidence which supports the claim and the parameters of the claim itself.
Yes.
So the parameters of the claim itself are set by the claimant making a claim under Section 1. They set the parameters of the claim. I want to be paid benefit from the 1st of March. That is the parameters of your claim.
Mm-hmm.
The evidence which you then provide to substantiate your claim
Yeah.
is evidence that can be provided
Yep.
on the ongoing basis, including post-decision.
I understand that.
That's the
Still got my question.
What I've written down, which is me anticipating what you've said about this, but I hope I've got this right. Revision is re-evaluation of the claim as made
Yeah.
on the basis of the material supplied, or in the case of backdating, material which you could have supplied if the Secretary of State wanted to investigate. But the premise of that would be that you made a backdating claim in the first place.
correct. That's the fundamental premise. So my lady has an outstanding question.
I understand the submission.
Yeah.
That a revision is just a revision to the decision of the claim as made. I get that.
Yeah.
What I want to really understand is where I get that in the legislation we're looking at. You said it was the interaction of different provisions, and I've got myself as far as Regulation 30, which I think is what we've done.
Yes,
You said to me that was my answer.
I apologise.
That tells me that
Yeah.
you can amend. This is the point, but you can amend a claim any point at any time up to its determination. We want determination for 1 month. I understand that. But I thought we were dealing with reviews to determinations that had already been made. So Regulation 30 doesn't help me very much because I'm dealing with the other side of the coin.
yes. So one, again, not having anticipated this, it's quite essential. But if one looks back at Section 9 on page 21,
Yeah.
behind tab 2 then.
Yeah. Yeah.
Certainly my understanding of the structure, and I'm trying to anchor it now in the wording, is that it is the same matters that's reviewed again. And that appears to be the Section 9 subsection 2 point. But if I can just have a moment.
Well, I'm sorry, perhaps that was what you were just saying. But 2, in making a decision under subsection 1, the Secretary of State need not consider any issue that's not raised by the application. I see that's the application to revise. And the word is revise, not review, which is, I think, a significant difference.
So you apply for a revision. The Secretary doesn't need to consider anything that isn't in your application for revision. He could consider something if he wanted to that was outside your application, as I understand this. Is this what you rely on to say you can't on a revision raise a point about retrospection?
Before I give you a direct answer to that, just let me check there's not anything in addition, because there may be.
Yeah, we need to see the regs, don't we? I mean, the statute, I appreciate it all comes ultimately from the statute, but we ought to see the regs as well, which we haven't got.
Yes, and I didn't anticipate there is some authority on this. I hadn't understood the case to be argued to be saying.
Well, I'm wondering whether we want to wait and see how Mr. De La Maya does put it.
Yes, well, I'm certainly content with that. It's because my lady Justice Whipple has asked me directly, and I want to give a direct
Yeah, it's
answer.
paragraph 15 and 16 of Mr. De La Maya's Skeleton.
But I just states the provisions. It doesn't make an argument as such.
And it is, I mean, I'm quite happy to deal with it in whichever order anybody wants to.
Yeah.
But you know where I'm coming from. I just want to understand the statutory basis or the regulation basis on which you say, if you're in the territory of a review, it doesn't go as far as you being able to say, I want to backdate my claim because I've just realised I can. I didn't realise that until now.
Yes, well, that is what we say, but I think I'm going to have to listen to it, because I don't read 16 as going as far as that, as the court does.
Maybe me then. You're absolutely right. Let's leave it on one side and wait for the submissions.
So how do we say it works? Well, one takes the examples in the respondent skeleton argument. So they provide a couple of examples. So what a paragraph 34 of the skeleton argument at page 19. So respondent asks, for example, consider a person who made a claim on 10 February 2023 and who...
Sorry, I was just looking at something. Where are we now?
A respondent skeleton argument, so core bundle tab 2, page 19.
Yeah.
Consider a person who made a claim on 10 February 2023 and who being...
Sorry, I'm still not there. Page 19 or para 19?
Para 34, page 19.
Okay, I've got it now. Yes, thank you.
Consider a person who made a claim on 10 February 2023 and who, being exceptionally well advised, expressly asked after completing the form for benefit to start from 10 February 2023 and said they could not reasonably have claimed earlier because of disability. If SSWP overlooked their express request or disagreed on the reasonable issue, how, if such a restriction existed, could that be challenged? We say that could be challenged. It could be revised because it's an error of fact on the claim as made. So the individual has presented the claim squarely asking for the period to run from an earlier date. The Secretary of State has erroneously not determined it on that basis, or potentially erroneously, we don't know. But that's precisely the situation that then can be accommodated by revision.
Or by appeal.
Yeah, it's just wrong.
I don't quite understand the relationship between appeal and revision.
I think appeal then has to go to the tribunal.
Well, I understand that, obviously, but I mean, I don't understand in what circumstances you appeal and what circumstances you ask for a revision.
Yeah, revision first, and then appeal second.
I see. It's rather like in the immigration and asylum field where you ask for a review,
correct?
An administrative review, and then only afterwards do you normally appeal. I see. So, yeah, okay.
Then second question, what would happen in cases where due to some other error, no benefit at all was awarded, or because the claimant was incorrectly found ineligible, and therefore was simply no determination by the...
Same answer.
Same answer, yeah. So that is the legislative framework. You have regulations 31, which deals with withdrawal of a claim. I don't need to show you that. And regulation 36, which just establishes then the fact that universal credit claims are for an indefinite period. So our ground of appeal is that we say a claimant who wishes to receive universal credit must make a claim for it, see section 1. absent a claim, no entitlement to benefit, and it is a matter for the claimant as to what is claimed, if anything. So the basic principle then, claimant decides if and what to claim, including for what period, and then the claimant, in the first instance, provides some information, expressly or impliedly, that supports that.
Just so that I can understand it,
Yeah.
obviously you could have an ambiguous journal entry, but if they were simply filling in the information in the form, the question of an implied backdated claim is hard to see how that could ever arise.
If
You're saying expressly or impliedly.
yeah,
Just going through the screens and submitting your
Yeah.
claim, there's no room for express or implied. That's right, isn't it?
there's no room for express or implied. Simply answering the questions on the form. I agree.
So express would be the journal saying, but by the way, I want to backdate, or the telephone call, but let's stick with the journal at the moment. And implied would be maybe again in the journal saying, not using the language of backdating, but saying something like, and I've actually been in this situation for a month.
Well, I don't want to necessarily say, but that might be an example.
But you've used the phraseology repeatedly of express or implied. I just trying to understand what implied would mean.
Well, that might be sufficient. It's for a decision maker. This is something that has to be determined. But we don't say that one has to say in prescriptive terms something like, I require backdating starting a month ago.
Yes, I see. Well, I may have mentioned it, so there's no mistake. If we go on after lunch, which looks like we will, we'll have to move to court 69 because this court is needed for another reason I needn't bore you with.
Yeah. Very well.
So when you come back after lunch, I think 69 is directly below this one. Thank you.
So the next stage of my submission is a series of tribunal decisions, but I'll happily show you the decisions. You have decisions which support my argument and decisions which support the respondent's argument. None of them are of this court, so they're interesting in that they reveal that there are two different alternative arguments, but you know that. But I'm happy to show you them to see how it's been considered by tribunals going back to the early 1980s.
My only worry about, well, I've got two worries about that. One is your point. Ultimately, it's for us to decide, and it won't help us just to see some saying one thing, some saying the other. But the other is also that the statutory framework, though similar, isn't the same, and then you find yourself in the kind of arguments that the Upper Tribunal was in, of saying, well, we do find help in this one, and I know the word's different, and they're not that different. I think we're really in your hands. I don't mind you taking the bold view of not taking us through them. In some ways, I quite welcome it. But if there are things that you want to rely on, do. But you'll then have to deal with whether the statutory provisions were different.
They were different. In a sense, the commonality between the statutory provisions is that in every case, one has to try and ascertain what it is that Parliament was expecting a claimant to do and what the Secretary of State was being expected to do. So knowing as we do that it is not adversarial, it's inquisitorial, there are obligations on both parties, what is it that invokes a jurisdiction to consider backdating? Because the Upper Tribunal's decision is effectively, you don't need to do anything at all. Whereas we say, well, there's got to be something.
Well, the strength of your position is, how is it supposed to work if someone simply puts in a claim, says nothing about backdating, and nothing, therefore, about the circumstances which would have to be investigated under 26(2)? How's the Secretary of State to know that they're supposed to be considering them? They may, they need a trigger. That's your substantial point, isn't it?
It is, and even the cases which effectively the respondent would say support their interpretation all talk about there being something from the claimant. So there is no case, really, properly understood, in which the tribunal says, well, you can just stay completely silent about this. So there has to be something which invokes a jurisdiction to consider the backdating, even on those cases where the interpretation is extremely generous, as it were, to individuals. One sees that in the first one, RSB 56-83,
Okay, well,
behind tab 8.
yes. That's one of the ones I looked at.
So the way that the Secretary of State had argued it, one sees at paragraph 10, and I won't trouble the court with all the facts, it doesn't particularly matter, it's just on this specific issue. The Secretary of State had said that, this is the bottom of page 124 of the bundle, it submitted that such claims should be made in unequivocal terms and should identify the period in respect of which the request is being made. The claimant's mother expressed no more than a vague belief as to past entitlement over an unspecified period, which was insufficient to give the benefit officer jurisdiction. Then one sees that immediately, being pressed by the tribunal, Mr. Qureshi, who's for the Secretary of State, says that that's an overstatement. It doesn't have to be unequivocal. And you don't need to be precise about this, but you've got to invoke the jurisdiction. Tribunal says, paragraph 11, these are deep waters. And paragraph 13, all of the questions that are being asked, perhaps also by this court, how's a claimant expected to know that? Where on the claim form is he expected to do it? And there we are.
It is, sorry, I can't help saying, I know we've been over the strand. This has been a known problem when it was all on paper.
40 years ago.
40 years ago.
Yeah.
Why on earth someone didn't grapple with this when they were redesigning the system is a puzzle.
My lord.
But you don't know the answer, and you can't. So, and you write, well, you would say simply it's none of our business. It hasn't been grappled with, and there we are.
Yes, I mean, certainly I investigated this matter, and me saying as an advocate, this is still under consideration. I mean, that is the position, but there we are. I'm not proposing to say anything more about it. What the tribunal says here, though, is that I claim all that to which I am by law entitled. I mean, this is effectively the high point of the respondent's case, that if you just say, give me everything, that should be interpreted by the Secretary of State as meaning, well, let's work out how best to maximise your cash entitlement. But that phrase itself is ambiguous, because give me everything to which I'm entitled. One reads back to section 1, you're only entitled to it when you've established the period for which you are claiming it for. So asking for all of the universal credit to which I'm entitled doesn't itself mean work out what period in time I should go back to, and therefore assume that I'm claiming from that date, because your entitlement is only founded on your claim from a particular date. There may be all sorts of reasons why an individual chooses not to backdate on the facts of the case, and it's that which is fundamental to all of this. The tribunal assumes that you should override the claimant and just work out what cash to give them for what period.
So that was the point about it's for the decision maker to decide. So the claim is made. So I understood the UT what they were saying. The claim is made, and then it's sort of open doors. It's the decision maker then has to work out what commencement date is. Is that right?
Yes,
and that's why they remitted it to the First-Tier Tribunal to do that exercise.
Two things. So they say, yes, they've got to, well, it is really actually just that. You've got to work it out, and that allows you then, because it's at large from day one, it allows you to come along at the revision stage and say, well, because it's always been at large, I can now supplement what I didn't say with all this new material, such as an express request for backdating. And that works if it truly is at large in the first instance. So the respondent's absolutely right on their revision point. If in fact it was always something that fell for determination, then there's no reason why they couldn't come along at a revision stage and say, well, I'm going to provide this information which supports my claim for backdating. Whereas we say, well, it was not at large at the outset because you hadn't claimed for it. See section 1. We go back to the starting point. And you can't, there's no way round that unless you've invoked the jurisdiction to applying for backdating, and you haven't.
Well, in a sense, the point, what's quite interesting is that 5683, which you regard as a case against you,
Yeah.
the decision of Commissioner Mitchell, it was considered the next year by a 3-person panel on which he sat,
Yeah.
and they said something rather different
Absolutely. So
in para 11.
yeah.
Something quite like what you have just
Yes, indeed.
saying.
So in a sense, it's interesting to see the case law develop, but it is right at paragraph 11 then, it's considered by, this is
Tab 9.
tab 9, yes.
It is odd. If that's the Commissioner's view, we disagree with it. So he is one of the people disagreeing with himself, but there you are.
It does happen from time to
It does happen, yes. It's rather bleak.
Yeah. Okay, so he's seen the sense of the arguments, and
The others have lent on him. Anyway, yeah.
so they say, well, it's got to be raised.
So that's one that you'd say that supports your argument.
Yeah,
is it?
that's on our side.
And I think so is 37193, the very next one behind tab.
Yeah, that's the paragraph 14.
10. That's Commissioner Mashuq.
But bear in mind, this is the point I made at the start, that even the high point then of the case against me is probably 5683, but even that talks about there being something to invoke.
Which one's against you, sorry?
The first one.
The first one, yes.
Yeah.
No, the point you were making there was she did say
Yeah,
something about the earlier period, but it was the argument being run by the Secretary of State, it was too vague.
yeah, correct.
Yes. Yeah.
And they have,
Well, I hadn't, I'm afraid. I ran out of steam to read through all of these. I'd read the early ones and had noticed, I'd noticed in particular 984 and 31793. I think possibly because they were flagged up in your skeleton, but
yes. I'm not sure, well, I submit you don't need to read all the rest of them. And the Upper Tribunal said, well, we were shown lots of other cases and frankly didn't really advance the argument that much. The Upper Tribunal is concerned about precedent and therefore has to distinguish by reference to legislative schemes. My submission is it doesn't actually make any difference because my submissions are effectively the submissions that were being advanced in those cases years ago. The precise wording here does not tell you anything different because this is ultimately about section 1 of the 92 Act as opposed to the mechanics within the regulations.
yes. Well, we bashed you around rather, in terms of taking you off course. You've made most of your submissions, but have you made all of them?
Well, my ground 3 is Upper Tribunal is wrong because it didn't do what I have just said. I can go through the reasons for all of that.
Well, again, we're in your hands. I'm all for being economical, but if there are particular errors you want to draw attention to, please do. Of course, you've got the difficulty there of two sets of reasoning to it.
2 sets of reasoning, but well, I'll do it very briefly. In a sense, there are short argument is that because they did not analyse it in the way that I say it ought to be analysed, it doesn't really matter what their reasons were because they're really wrong.
I'm relaxed about you leaving it that way, but it's up to you. If you want to nail in some nails, do. But if you don't, as you say. Don't care about their reasoning, they're wrong. But
I'll do it very, very quickly then. So just the key points, paragraph 24. So we're on the Tribunal's decision, tab 8.
It's a high-powered tribunal.
Yes, and I recognise all of that. There are plainly arguments that go both ways, but there's only one authentic interpretation of the statute, and it's not this one, so it doesn't really matter. The only point is it's wrong. Paragraph 24, it is an exercise of statutory construction. Then just paragraph 30, recording what the respondent's case was. Do you understand it to be broadly speaking the same? They say no requirement on making it, so this is paragraph 30, page 65. No requirement on making a UC claim to indicate the date from which the claimant wants an award to begin. Rather, contending the start date is a question of fact for the decision maker to determine when making their decision in the same way as any other issue of fact has to be determined. And that's the primary basis on which they put it now, which is that it's the same as your personal circumstances, and that it's at large. But that's not a correct comparison, because your personal circumstances are fixed and immutable for the purposes of the claim. Obviously, they change from time to time, but they're not something over which you have any control or discretion or autonomy. You can't elect to be 50 years old when you present your claim, whereas you can and must elect for the period of time for which you claim your benefit. Now, in the ordinary course, you do that just by making your claim, and that establishes, by reference to Regulation 26(1), that you're claiming from that date. But if you want more benefit from the state for an earlier period and you're entitled to it, then you must advance that claim. That's the policy of Section 1 of the 1992 Act. And in order to establish that backdating claim, then you need to invoke Regulation 26(2). So that is a false comparison, and the reason why the respondents' arguments are misconceived is to treat this as being somehow equivalent to the box of questions that we saw in the Universal Credit Form, which only require you to provide that objectively or ascertainable information.
Sorry, could you go back that last bit again?
Yeah, so the questions about eligibility. So, for example, date of birth, residential status, nationality, partner, work, income, etc. All of that is objective information which you are required to present in order for your claim to be determined. And you have no control over that. That's all objective fact. The scope of your claim, what you're claiming for, and when you're claiming it from, is a matter within your control. You decide that as a claimant, and therefore you need to elect for it. That's Section 1. And it's that, then, which distinguishes this issue from everything else which the tribunal said just falls to be ascertained as part of the evidence-gathering process. It's not an evidence-gathering process, it's the framework of the claim. What would be evidence would be the material that supports your request to have a claim date, which is different from the presentation date. So this goes back to the point I made before. You can volunteer more information to support your request for backdating, that's fine. But you need to have that request for backdating in play. Now 31, the argument advanced, possibly retreated from, and I think retreated from on the appeal, that you should, by claiming universal credit, be treated as being as claiming for the maximum amount of cash in any particular case. And this is virtually impossible position for the Secretary of State, because what that is saying is that in every case, there has to be some proactive assumption that you need to go out and find circumstances which might support a greater entitlement, and then you've got to actually see if the claimant actually wants that or not.
So it goes against the autonomy principle.
Yeah, absolutely, yeah, because you're assuming that they will, in fact, always want to maximise cash entitlement. Now, of course, taking an ordinary individual, one can assume that that is likely, but that isn't the way that the structure is established. Then thirdly, you do it on a case-by-case basis, but query why that's any different. You do what on a case-by-case basis? So tribunal then records Secretary of State's arguments, puts everything in the context of the earlier case law from paragraph 35.
We can really pick it up, can't we? Page paragraph 43, which is the reasoning of the majority, and they start with the statute.
So they say no requirement in the primary legislation to specify the start date. Well, we would say section 1 requires you to claim, and that includes the temporal period for which you are claiming. So it is right that it doesn't expressly say, oh, and you must say what the precise start date is, but that is
but in any
inherent.
In any event, it's subject to regs, isn't it?
Yeah.
And
Subject to.
Yeah, go on.
But I mean, this is a fundamental principle of entitlement, is that you do have to claim it. Then the regs themselves serve to establish what the start date is.
Yeah.
So regulation 47, this is when they say, well, it's a matter for determination. I've made my submissions that it is not a matter for determination because you claim it. Regulation 26 then 26(1) establishes what the start date is. It's the date on which you claim, unless you invoke regulation 26(2). But if you haven't invoked regulation 26(2), then it's 26(1). Straightforward.
So you say really paragraph 47 is where they go wrong, this bunch, because they don't respect the regulatory scheme.
Yeah, correct. Don't respect, or misunderstand what's the true scope of section 1 and then the regulatory scheme as well. And having then erred in that respect, one understands why they say that you can have a situation in which it forced to be effectively decided at large. But I say that that can't be right because they've misinterpreted the way the scheme operates. And basically, decision maker determines the claim date to be a different date if the claimant seeks to rely on 26(2) at any time up to determination of the claim, see regulation 30. And that's a straightforward scheme, and this is intended to be straightforward in that respect. This analysis is the antithesis of a straightforward scheme because it throws up into question in every case a fundamental issue, which is what is being claimed for. So in that respect, one can use the system, as it were, to see if that it does reveal anything about Parliament's intention. But we say it is highly unlikely that Parliament intended for a rigorous and prescriptive scheme, in fact, to be operated in a way which throws up a fact-specific, as it's described in the second submission, case-by-case analysis in every single one of the many millions of cases.
So they reject your Mr. Hoban's submission at 50. We haven't got there yet. So I get where you are on 47.
Yes.
Yeah,
And I think you're not quite making the same points. I think Mr. Hoban was saying that the requirement is that the applicant must specify the date of their claim. In fact, we've looked at it, it's more like a statutory deeming provision, isn't it? That the date of your claim is the day on which you put it in, and that's in fact how the process works as well.
Yeah, the way I would put it, and I think perhaps in slight respect for disagreement, is 26(1) is a deeming provision which will apply in any case other than a case where 26(2).
I mean, even deeming isn't quite the right word, because deeming suggests
Treating.
that it's something that isn't like that, but you're going to treat it as if it was something different. It's almost a default position.
Yeah.
26(1) is your claim must be from day one. Therefore, if you make a claim, you are by definition making a claim that's from that date only.
Yeah.
Subject to the exceptional provisions in 2, which allow you to backdate, though that word isn't used.
Yeah.
So I'm not sure that it's quite the language of implication or the language of deeming. It's just how you could actually say it is the effect of the statute as written. It's not the most perfect bit of drafting, but it is actually what it ends up saying.
Indeed, yes. It is simply application of the system is that it starts the period. So 26.1, you present your claim, and in the majority of cases, that is your claim, and that's the start date for your relevant period for universal credit. It starts on that date, and then the monthly cycles apply thereafter. If you're not doing that, then it's 26.2. And that is simple. And it should be interpreted in that simple way by the tribunal. Yes, insofar as Mr. Hoban's recorded as saying that's a clear implication of Regulation 26, I would say that that is just what 26.1 says. It is clear. And then one gets into they're not semantical arguments, but everyone uses all sorts of adjectives about the language of the statute being not pellucid, etc., etc. Well, it sort of depends on what you think it's supposed to say, because my submission is this is very clear. Okay, could be improved, fine, but it is clear what the statute is intended to do. It is pellucid. It only lacks that clarity if one thinks that it's trying to do something else. So the starting point for the tribunal's criticisms are in a different place. And I don't consider that I need to then wrestle with all of these arguments about language in circumstances where...
They're all different ways of making the same point.
Yeah, we've just started in the wrong place, and there is a logical fallacy which underpins all of this, namely that it's for the decision maker to decide the matter at large. Then they distinguish RSB 984, but I've made submissions on that.
Then 69 is the para I've referred you to.
Indeed.
Where they say that as a matter of principle, the meaning can't be altered by the fact that the Secretary of State's forms are incredibly unhelpful.
Yeah. And then Judge Jacobs has a slightly different perspective, and one can see it if one very carefully goes through the analysis. But again, it's just the different starting point as to how the scheme is intended to work in terms of what a claim means. We say, well, it's not that complicated. The claim is the claim that you present, and therefore 26.1 applies. And respectively, the analysis is unnecessarily cumbersome when one approaches this from the correct starting point. Not proposing then to try and put any particular nails into the minority judgment. It has the same logical fallacy. So no relevant parallel with other characteristics of the claim.
Okay. We there?
We are there. Let's assist the court. I think we've got those documents which we'll hand up, but those are our submissions.
Very well, thank you. Better look, yes, do that a bit later when you've had a chance to look at it. Yes, Mr. Delamat.
My lords, my ladies. As the Upper Tribunal correctly identified at paragraph 24, that's page 64 of the bundle, of their ruling, at the heart of this case is a central question of statutory construction. The rival arguments boil down to this. On the one side, the Secretary of State for Work and Pensions. Does Regulation 26.2 of the CMPR regulations amount to a regulation which, read on its own or read with Regulation 26.1 and its parent enabling legislation, and Mr. Brown has put particular emphasis on Section 1 of the 92 Act, does that together require a claimant to specify an earlier period in his or her application if she or he is to have an entitlement to such period? That's the Secretary of State's case, and we can call that the claimant specified period construction. Alternatively, do the same materials, Regulation 26.2, read with 1, read with the enabling provisions, simply amount to a deeming rule under which, if certain facts are made out to show that there was a specified type of impediment to the claim being made earlier, which it is at first blush for the Secretary of State to decide on the facts, does that then require the claim to be treated as if made a month earlier than it was in fact made? And we can call that construction the fact-finding construction. Now,
just characterise what that construction is again. I lost you at the word deeming.
Does the legislation amount to a deeming rule under which, if certain facts are made out, yeah, you are required to treat the claim as made up to a month earlier than it was in fact made? So you find the facts, you apply the facts to the deeming rule in 26.2, and the deeming rule supplies the date of claim. Now, the difference between these two stances is this. On the claimant specified period approach, the Secretary of State's approach, the requirement to make a claim for an earlier period is in fact a jurisdictional requirement. Without the claimant taking the steps the Secretary of State says she or he has to take, there is no jurisdiction for the Secretary of State to apply the rule in 26.2. And it follows from that there is no power to revise such a decision. And the genesis of this case is all about whether or not there was a power to revise. The First-Tier Tribunal concluded it had no power to revise because the claimant had never made the claim. So the jurisdictional element was missing.
I started it, I'm sorry. There's a misunderstanding. There isn't some special point that revision means all the rules don't apply. The points you make in your cellus about revision is simply that's how we got there. That's how we got to the present issue. No, well, that's what I thought, but I misled myself later.
Exactly, because the difference between us is as to whether or not there is a jurisdictional requirement to do a certain thing. If the Secretary of State there is no power to revise. That's the argument he has made all the way through. We say there is no jurisdictional condition to be satisfied by a claimant, so there is a power to revise. And you can see this most clearly from the way the Secretary of State put his case in writing. Page 6, paragraph 13.3. This aligns completely with the way Mr. Hoban put the case below. It is said...
Which bundle are you in?
The core bundle, my lady.
Bundle 6.
Page 6, paragraph 13.3. Learned Friend's skeleton argument. If the claimant fails to present the claim on the first day of the period in which the respect of the claim is made and presents the claim on a subsequent date, the Secretary of State must decide whether to extend time by reference to the criteria. If a claimant seeks to rely on Regulation 26.2, they must, here's the jurisdictional requirement, A, identify the claim date, namely the first day of the period in respect of which a claim is made, and B, they must identify the basis on which the Secretary of State should determine to extend the claim date to the date on which the claim is made, i.e. by reference to the criteria in Regulation 26.2, which I think must also mean in 26.3, disability or one of the other grounds thereby identified. So the case made below, and it's very important to understand this, to understand the Upper Tribunal's reasoning, and the case made until this morning, was there are two jurisdictional requirements. You have to specify that you are claiming a particular period, and you have to specify the grounds effectively upon which you seek an extension. If you don't do that, there is no jurisdiction for the Secretary of State to extend.
Is the second bit right? when I was reading through this, I made a note. This isn't quite the most helpful way of putting it. Surely what the Secretary of State is saying is that the claimant must identify the period in respect of which the claim is made, because that's actually what we're concerned with here. And claim date isn't a statutory concept. On the other hand, since the period doesn't have any end date, really what you're talking about when you talk about the period is you're talking about the start date. So claim date isn't totally wrong, but it's just, we're talking really about period. If that is done, suppose they said, they put in a thing on the 1st of February, and they said, if the box allowed them, or on the telephone, whether they can say what they like, they said, I want to claim from the 1st of January, then they have made a claim for that period. The requirement then to explain whether any of the circumstances under 26(2) arise, I don't think you call that jurisdictional. That is simply a consequence of them having made a claim for a backdated period.
Yes.
And the Secretary of State then needs to make a decision on whether the 26(2) criteria are satisfied,
Well,
for which he will need some information.
that is the position to which my learned friend moved this morning. Because effectively this morning, I abandoned any attempt to rely upon B as a separate jurisdictional requirement.
I
And he
see
said
why
in
you're doing
relation
it,
to-
but I think picking points in the skeleton, maybe a helpful basis for making your submissions, isn't really what matters for us. It's actually working out what the right answer is.
Well, with respect, my lord, the reason it's important is this. It ties into the exercise of statutory construction, because what the court must do is parse Regulation 26(2) to see what conditions Regulation 26(2) impose upon the claimant. And that's exactly the exercise of construction that the tribunal did, as we shall see.
Can I just pause there, though? I just want to understand this. 26(2) doesn't, in a sense, impose obligation on the claimant at all. What 26(2) does is it imposes an obligation on the Secretary of State, is to, a slightly odd phrase, but clearly means must backdate, if I can use the shorthand, by up to a month,
Yes.
if certain conditions are satisfied. Now, at that point, there is a practical obligation on the claimant, because the Secretary of State can't know whether the conditions are satisfied without help from the claimant.
Yes.
But that's not a jurisdictional matter. The
Correct.
jurisdictional point comes from 26(1).
Correct. And the consequence of my lord's point is that even if there is a deficiency of information, because it's not collected by the forum, and the claimant is not exceptionally well advised to amend the journal after the submission, if facts thereafter come to the attention of the Secretary of State by means of an application for revision, a revision at that point is possible, because they were the circumstances that always applied at the time of the making of the claim.
All that is correct, except that that's only so if they have made a backdating claim in the first place.
Now, that's the nub of the issue.
Well, I know it is. That's
Is
what I'm
there
trying-
any obligation to make a backdating claim?
But that, exactly, but
That's the
I think the
issue.
focus is, what I'm trying to get at is the focus is on 26(1). 26(2) arises only if, exceptionally, as far as the structure of the Act is concerned, you are making a claim which doesn't start on the date you put in the claim for.
26(1) we'll come to. I want to go through the actual text of the provisions quite
Of
carefully.
course.
I mean, it's quite surprising for an exercise of statutory construction. My learned friend hasn't actually grappled with the language. Of the
Well, don't worry
provision.
about that. You can do it.
So we'll get to that. But 26.1 is a provision that does, as my lord put it quite rightly, supply a default rule. It's a default rule that's populated by one fact. And the one fact is when the claimant chooses to make a claim. And the default rule is if you make a claim on the 1st of April, and you've completed it by pressing send and the form's complete, that is, absent something else, the date of claim. But it's very important to appreciate that even Regulation 26.1 starts with the wording subject to the further
Yes.
provisions of this regulation. So we'll come back to that. But that is the nub question. What is required from the claimant in order that the 26.2 jurisdiction or power
Yeah.
is accessible?
Yeah.
And that's why it goes to the existence or not of a power to revise, and my lord has my point. We don't make any point out of the particular powers of revision, and there clearly was a tenuous application to revise, and we have the regulations which we can put on your desk.
They're the regulations that go with Reg 9.
They're the regulations under the decision-making regulations, the ones we omitted from tab 7 of the bundle.
Yeah.
Have to put
Well,
on.
it's useful
Nothing
to have
to-
them, but now I understand that you're not making a separate point based on the revision.
Yeah.
power. It all feeds back into the original point.
Great.
Yeah, okay. Well, let's
So,
have them. But
That's
they
the
don't.
debate. Can we just pause to ask ourselves how the two strands of the very experienced Upper Tribunal address this? The reasoning of Judges Whiteley and Wright was on the following simple basis. Firstly, that the primary legislation, whilst requiring you to make a claim, does not, either directly or indirectly, require you to specify the period of any claim, unless there's some form of contrary indication in the secondary legislation. And that's the second strand of their analysis. The second strand of their analysis is that there is nothing in the text of Regulation 26.2 that required some further act from the claimant in order to access a particular
Knowing you, the
period.
answer will be yes. But did you say 26.2 advisedly? Why shouldn't you be looking at 26.1?
Because Regulation 26.1 sets the default rule, and the question is there anything in Regulation 26.2 to condition the triggering of the exception from Regulation 26.1? So
Is there any obligation on the claimant to do anything?
Absolutely.
26.2.
absolutely. So one analysis, Secretary of State, is the claimant has to take a step. I wish to invoke 26.2, and if you don't say, I put my hand up, I want 26.2 to apply to me, it doesn't apply. On the tribunal's analysis, and indeed this is the same on Judge Jacobs' analysis, the question of whether or not 26.2 applies is simply a question of law applied to the relevant facts before the fact finder, and then no action is required from the claimant. So suppose, for instance, that by dint of the particular history of a particular case, the Secretary of State already knew all of the facts in relation to a particular case. They knew all the details of a disability. They knew, for instance, that someone was in hospital in a coma and couldn't have claimed earlier, whatever the facts may be. If they have those facts, they can't ignore them. The law requires them to apply the facts to the particular rule in question.
Well, I'm not sure that's very helpful. And surely any system like this must be keyed on what information is supplied for the purpose of the claim. The situation in which the Secretary of State is fixed with a duty because of things that the official happens to know because they're presumably came to his or her knowledge from some other claim, and that they're therefore in a different part of the computer, it surely is irrelevant.
Well,
You'd never know what was there. It would be, and what if the Secretary of State happened to live next door to the guy and knew he was in a coma?
With this-
It's got to be what's submitted with the claim, hasn't it?
What the Secretary of State has before him at the time of making the original decision will obviously inform the original decision taken. But the question we're asking is this: if further information is supplied within the time limits permitted for a revision that show the circumstances pertaining at the time of the relevant decision, can you take them into account? We say yes. Or are they debarred from being taken into account? The Secretary of State says they are. Why? Because he says there's a fatal problem. The claimant never said they wished to invoke Regulation 26.2
In time.
in time. That's the point.
Yeah,
It
no,
comes
we all
down
agree
to-
what the point. We all agree what the point is.
So-
The
so,
question is,
of
what does
course.
the statute say? Or actually, I think, what does the reg say?
Absolutely, that's the central question. And before we get to that, can I make 4 general points? The first, and I don't shrink from this, is how spectacularly poor and unclear the drafting of Regulation 26.1 and 2 is. It's a point the majority made at paragraph 55, describing it as less than pellucid, which I would suggest is a masterpiece of litotes. Regulation 26.2 and 3 read like language originally used for a more conventional backwards-looking limitation purpose, which has been unthinkingly clunked into a regime whose default in Regulation 26.1 is prospective only entitlement.
Do you, are you saying it reads like that, or are you saying you happen to know that that is the case?
It reads like that.
You can't say, and actually, look, back in 1975, it was.
No, because the language in the regulation is quite different to the earlier regulations considered in the earlier cases. When you look at the earlier cases, I'll show you the provisions that apply to supplementary benefit, and my lord and my ladies will immediately see that that language, which requires a claimant to show the existence of good cause and expressly puts a burden of proof to make a claim and to show good cause from the claim for claim for backdating, is markedly different to the language of Regulation 26.2, which is what, in my submission, makes a lot of these old Commissioner decisions actually irrelevant, because they're about different benefit schemes and very different statutory language.
So is the short point that given the default position, the language should be different and certainly clearer?
Absolutely, my lady. It's a singularly deficient piece of drafting in an area where, because of the very vulnerability of the people Regulation 26.2 and 3 is designed to protect, it's not just that they're financially vulnerable, it's that their facts make them particularly vulnerable, whether it's because of disability, whether it's because the system has crashed, whether it's because of illness. It's those further factors that would call in the ordinary course for very clear language if they're expected to do something in order to access this entitlement, which is meant to be available to them because through no fault of their own, they haven't been able to claim earlier.
Mr. Brown, no doubt, having been at the receiving end of quite a lot of questions, got to the position where he said there had to be a trigger
That's right.
which emanated from the claimant.
That's right. And the nature of the trigger he's suggested has diminished. So you have my point about Regulation 30, paragraph 33, that was a very large set of triggers. We're now down to, I think, simply making some cognisable indication that you wish to invoke Regulation 26.2. The second point to note, and I've made this point already, is that the argument here, and it's a point Mr. Royston made when resisting permission, the argument here actually proceeds by way of assertion. It proceeds by way of asserting in paragraph 13.3 and then 21, 21.1, page 7, and 22.1, page 8, asserting the very thing to prove that needs to be proved without actually anchoring those submissions in any way in the language of Regulation 26.2. There's literally no textual analysis or attempt to support it as a conclusion by reference to the detail of the operation of 26.2 and 3. The third point to note, and I think as a result of the helpful exchanges this morning, this one should be easy to explain, is that the legal implications of the claimant's, of the appellant's approach is that there is in fact only one way for an exceptionally well-advised claimant to get home. And that's by the claimant making the claim and then immediately opening the journal and indicating in the journal that you wish to invoke Regulation 26.2. That's the circumstance that we identified in footnote 2 of our skeleton argument as being the only way that there is any practical reality of making the claim.
Except in the case of a telephone claim, which is itself very exceptional.
No, with respect, that's not what Mr. Brown said this morning in relation to that, not correct, and I'll show you why in a moment. The alternative of making a separate claim doesn't work, both for the reasons given by my Lady Justice Whipple, which is that by the time you realise you want to make a separate claim because you've got your first payment and you've seen the date from payment, it's too late. That's the point made by the Upper Tribunal, as it happens, at paragraph 5 of the rule. They say this route doesn't work because it's too late. It also doesn't work for the further reason, how do you make such separate claim? You can't identify the period in the box at any stage. The only way you could make a separate claim is by going through the very boxes you've already completed and then putting in a journal entry.
Where does this point get you? Are the Upper Tribunal wrong to say that this is all very unsatisfactory, but it can't bear on the question of construction?
The practical implications of a construction in terms of what remedy is provided for an error of this kind is a relevant feature. So what the Secretary of State has done on his forms, that's a different matter. But the practical implication of a particular construction, of a particular regulation, in terms of its impact upon the rights to review, appeal, etc., and the operation of the jurisdictional requirement is relevant. Because if, as a matter of law, your remedy in relation to a particular circumstance is vanishingly small, that supports the contrary construction.
Just suppose, but well, I wonder if that's right, because at the time that the Act was passed, nobody knew what the Secretary of State's forms were going to look like.
Yes, but the point remains, nevertheless, that if there isn't a facility to provide this information, that will be the consequence.
Well, all right, but that, anyway, I mean, perhaps you can test it this way, can't you? You can say, suppose we were dealing with paper form, well, then let's stick with online forms. But simply, there was a separate online box which simply said, in respect of which period are you claiming?
Yes.
And maybe to make it helpful, tick 1 as from the date of this claim.
Yes.
Tick 2 for some claim up to a month previously.
Yes, and you could have a drop-down menu of...
Yeah, exactly. Okay, now suppose it said that. You would say that was wholly redundant because the Secretary of State is under an obligation anyway to look at the whole period back a month, aren't you?
We would say that that is no more than the Secretary of State discharging his duties of inquiry in relation to a topic that he is in fact required to investigate properly and ask sensible questions in relation to. And whether or not there exists in any particular facts of any particular case a basis for an extension is a matter that the Secretary of State should properly be considering.
But it would make no legal difference that there was such a question on the form. The duty would exist on him anyway.
It makes a legal difference only in this sense that if those questions are asked and not answered, then the form becomes defective. Absent the questions being asked, if you answer all of the questions in the prescribed form in the manner asked, the claim is not defective. And it's another peculiarity of the Secretary of State's case that they don't say we have to make a discrete claim because we can make our claim by amendment, and they don't say that the claim that has been made is in any way defective. It's a pretty strange set of affairs. The fourth point I wanted to make is this. My learned friend concentrated a lot of blood and treasure on our alternative case, which is that if there is any obligation on the claimant to specify a period, then in the face of silence, you must presume that the claimant is asking for the most time possible. But that is an alternative case, and always has been. Our primary case is the Secretary of State simply decides the matter on the basis of the facts before him. If the facts at the time don't suggest any basis for the triggering of Regulation 26.2, so be it, but it's still a topic that can be revisited by way of revision.
Sorry,
As to that
just say
alternative-
that again. I haven't understood your point on this.
So, Secretary of State asks no questions. I supply no journal information. I apply Regulation 26.1 and by implication 26.2 and decide the only date for the claim starting is Regulation 26.1. The claimant in those circumstances can nevertheless supply additional information as to the circumstances pertaining at the date of claim to show that the claimant was entitled to get within Regulation 26.2 and that there should be an extension. And there is no jurisdictional bar to those facts being presented for the Secretary of State to consider upon revision.
Still don't understand, sorry. You say that's only an alternative case.
No, that's our primary case. The alternative case, which my learned friend spent a lot of time addressing, is the alternative case about if you haven't specified a time, do you, as some of the earlier Commissioner decisions suggest, assume that the claimant is claiming for the broadest period possible? So do you effectively imply?
Yeah, no, I understand that's the alternative.
That's the alternative case.
Well, I was just confused. So you're saying something more modest. What is the something more modest that you're saying?
I'm saying that the floodgates scenarios that my learned friend is painting of every decision having, they only arise on the alternative approach.
Yes, but why is your primary? I'm being slow, I know, but just tell me one more time. What is your primary non-floodgates argument?
Our primary non-floodgates argument is that Regulation 26.2 does not impose any requirement upon a claimant to do anything. It imposes no jurisdictional requirement for that section to be live.
Yes.
It is simply a question of law that will arise to be determined upon the
You mean
fact.
law or fact?
A question of law to be determined by reference to the facts pertaining at the time.
But how will the Secretary know the facts that are pertaining at the time?
The Secretary of State won't know at the time of the original decision, but will know upon revision.
So right?
So it's
no,
curable.
let me put in my own words, and then you'll see it. You tell me. You can see where I'm misrepresenting you, or if I've understood you correctly. The maximum possible claim alternative, which is the floodgates alternative, won't arise in practice very often, because how it'll actually happen in practice is that someone will get the claim which isn't backdated.
Correct.
They will ask for a revision at that point, and in the context of asking for the revision at that point, they will then supply the information.
Correct.
Right, so I have that. That's what your case
That's
is.
how it works. If there is no jurisdictional bar, then a claimant can say, well, in fact, at the time of the claim, I was disabled and I couldn't have claimed earlier for the earlier month. Please, may you revise the decision so that I have that additional entitlement. And that decision on revision can be made by reference to all the facts. And if there's further fact-finding required at that stage, it can be done.
Is
So-
that dependent on a signifying a claim? Is that dependent on the claimant coming forward and saying there's more that you need to know? You've got the wrong date because.
Yes.
So it is dependent on the claimant doing something.
It is, my lady, and doing so within the time limits themselves, which are quite strict, for asking for a revision.
And in a sense, that will always be so, because even if the Secretary of State's in breach of their duty because they haven't investigated the maximum possible claim, that will only ever arise because you ask for a revision, and if you don't get it, you ask for an appeal. And at that point, you'll say what the true facts are. So that really the maximum possible, the Secretary of State will never in practice have to do this. They will, because of the funny way they've designed their systems, they will pay on the default basis. When you say, no, I want to backdate, then in the context of the application for revision, they will be presented with the true facts, and
Absolutely.
we'll make a decision at that point.
And that's not some insuperable problem for efficient decision making. It's simply that certain cases someone will step up within the time limit.
It's a pretty clunky way of doing it, because it's always you make a decision, then you're asked to revise it. But you say that's a problem because you didn't ask the right questions first time round.
You anticipate my last point. It is hard to overstate how factually unattractive the Department of Work and Pensions case is in circumstances where they have taken no action at all to invite claimants to identify whether or not they make a claim and in relation to what period and on what basis or grounds.
And this is particularly claimants who have their own vulnerabilities.
Absolutely, my lady. Particularly claimants who satisfy the Regulation 26.3 criteria, who are a subset of universal credit claimants. There is not a blank text box, as you know, before you make the claim. Your only opportunity is to fill in the journal. The journal, as I invited my learned friends to draw your attention to, if you look at page 103, says in terms you cannot submit a message on the journal until the claim has been submitted. So it's post-claim and effectively amendment by any other name. If you look at the 3 bullet points on page 103, what you're meant to use your journal for, add details about your work search, that's about continuing entitlement, leave messages for universal credit, and view your universal credit account history. Frankly, unless you have accessed CPAG or some other form of independent advice that knows their way through this deep and devilish arcana, there is no way that you're going to know that you can and should use the journal in order to extend your claim. It was suggested that somehow telephone calls were different and that you could supply further information in relation to telephone calls. My lord was justifiably annoyed with me earlier when I tried to stand up. The case of GDC, which is in the bundle of authorities, might I ask you, if you have the time, I appreciate it's a cheeky request, to read that over lunch, because what GDC does is supply a very detailed stage-by-stage walkthrough of how an account is opened, how you fill out the boxes, at what point you're able to submit a claim, and how and when the journal becomes accessible. It's effectively the answer to all of the questions my lord was putting to Mr. Brown this morning. It's GDC that also tells you in footnote 12 that 98% of the claims are made by use of the form. It's footnote 8, sorry, footnote 8. Page 288. And it's also that footnote that tells you that the exception for a telephone call is more apparent than real. Why? Because the DWP agent taking the claim by phone inputs the information directly into the online UC system. In other words, they've got the same form open in front of them, and they're simply interrogating the claimant for the answer that would be used to populate the same form.
So they couldn't put it in either. They could, in theory, write it down on a piece of paper, but the system wouldn't allow them to do anything with that bit of paper.
So. And you know from the facts of this case that there were, and this is in the facts as found by the Upper Tribunal, I think there were in the order of 3 or 4 telephone conversations between the claimant's parents and DWP in which no one sought or volunteered this information.
I suppose what the most you could say is this: if during the telephone conversation, even if it off script, not prompted by any question they're asked by the caseworker, they said, by the way, I want to backdate, the caseworker who knows the way the system say, oh, okay, as soon as we finish the form, I'll pick up I'll open the journal and put that in. That's so the caseworker could do that and would, but there you are.
perhaps.
But the telephones, I mentioned it just for accuracy, the telephones are a bit of an irrelevance.
They are.
If the whole thing's irrelevant at all,
Yes,
we've got to take into account what the position is for most cases.
I wholly concur, Michael.
Yeah.
So, with those points of introduction, let me turn to the main submissions I want to make on the topic of construction before I get on to the much shorter topics of varies and the relevance of the previous commissioner decisions. And our case on construction proceeds on the following 9 principles. The first principle is
We need 9, do we?
well, you'll be pleased to hear some of them aren't, I don't think, disputed.
Okay.
What is required to receive a benefit, unless the legislation says otherwise, and that is an important proviso, is in general for the claimant to make a claim for the benefit in question.
Sorry, do you want us to write these down? I mean, if they're important, we ought to write them down.
Yes, I
Well, okay. So, what, do you give me that one at dictation speed?
first, what is required in order to receive a benefit, unless
Hang on. Yeah.
unless the legislation says otherwise, is for a claimant to make a claim for the benefit in question. And that's the requirement that comes from section 1(1)(a)
Yep. Okay.
of the 1991 Act.
Yep. Got that. 2.
The relevant benefit
Is this point? Is this your second principle?
This is the same principle. The relevant benefit is identified by the relevant legislation.
1992 Act.
Yeah, and here the relevant legislation is section 1(1) of the Welfare Reform Act, which creates the benefit of universal credit. That much is common ground, and it is common ground that Mr. Miah has made a claim for universal credit. Second proposition, even that general rule, which is the centrepiece of my learned friend's case on claimant autonomy, can be departed from by a regulation that says there is not a need to make a claim. And that you can see from section 1(1)(b), because it provides that there will be circumstances where regulations will say that you are to be treated as making a claim. If you want an example of where that operates, winter fuel payments. If you're in receipt of state pension or pension credit, or you're otherwise known to DWP to be in excess of 60, the relevant age to receive a winter fuel payment, you'll get a winter fuel payment automatically, whether or not you claim it. So there's no claimant autonomy where the regulations say otherwise. And that is material in our submission to the strength of the principle my learned friend identifies. The third proposition is that what is in general required of a claimant is only a claim for the benefit. You don't have to claim for a particular amount. You don't have to claim for particular allowances or increments that may be available in certain circumstances. Your entitlement to the amount of benefit will flow from the information that you've provided in.
So here, it's a claim for universal credit.
Absolutely.
Okay, brilliant.
So the default is that all issues of quantum, increments, etc., are decided by the defendant, the DWP, once a claim has been made with the information that's been supplied. Fourth proposition. As to the manner of making a claim, the DWP can make regulations governing that manner and the time at which a claim may be made. And these are effectively rules as to process or form, or rules as to effectively limitation. And that flows from section 1(1)(a), which we've already looked at, but also from the terms of 5(1)(a).
Yeah.
5(1)(a) provides for regulations requiring a claim to be benefit to which this section applies to be made by such person in such manner and within such time as may be prescribed. And that is the foundation of the rules in Regulation 8 and Schedule 2 as to the manner in which you make the claim. And it's also the foundation of the timing default rule in Regulation 26.1. All of that is explained in the GDC case, the reference for which is Authorities 19, page 281. Can I just identify the passages that are of particular help? Paragraph 8, which explains, page 283, that the system is digital by default. Paragraph 18, page 285, explaining the 3 things that are to be done by the claimant. Paragraph 24, which is the switch to emphasis on form, not substance in universal credit. And then paragraph 30 onwards, the critical passage at 287, effectively walking you through the various ways in which claims may be made, through to paragraph 47, and then lastly, the passage at 88 and 89 at page 306. That's manner of claim. But what we're arguing about here is the rules of limitation effectively supplied by 26.1.
Are we still on Bill point 4?
Yes.
Yeah.
And 5.1a, read with 1.1a, does enable the setting of the default timing rule in Regulation 26.1. And that default rule, I think we're all agreed, effectively says claims are prospective, because the first day of the claim is the day in which the claim is made. Now, the default rule doesn't have to be set in that way for any particular benefit. It could provide, in a fashion more familiar to lawyers, that you're claiming about an accrued or past entitlement, so long as you claim within a certain period. And again, winter fuel is a very good example of that. You get winter fuel payments by reference to a particular year, 2022 to 2023 being the current one, and the rules provide that you must make your claim to get that payment, if you're not already known to the system, by the 31st of March 2023. The clunkiness of the rule in Regulation 26.1 is probably explained, we submit, by the need to formulate it in terms that seems to correspond with the vires in Regulation 5.1a, to make it a timing rule. Fifth proposition, the legislation gives the Secretary of State for Work and Pensions different powers to make regulations permitting or requiring the backdating of claims, and in a way that caters for conditional or distinct situations to address what are in effect late claims. And that is the power in our submission that is found in section 5.1b, which I don't think you were shown. It provides that regulations may provide for treating such a claim made in such circumstances as may be prescribed as having been made at such date earlier or later than that at which it is made as may be prescribed. In other words, it is the vires for a deeming rule that provides effectively for what we've all loosely called backdating effect. Backdating from the default date in Regulation 26.1 if certain prescribed conditions are met.
So it's the vires for 26.2.
It's the vires for 26.2. And therefore, the exercise of statutory construction boils down to working out what are the circumstances prescribed by the rule that govern its application. In other words, what are the conditions set upon that exercise of backdating? And that is the central exercise of statutory construction. That is the introduction to the sixth principle, which I'll address after lunch, which is the construction of Regulation 26.2 itself.
Could do it before lunch if it was.
Very well.
Depends how many minutes it lasts. Have a go.
Sixth proposition. There is nothing express, as the tribunal rightly found, nothing express in the language of 26.2 that requires the claimant to do anything, still less to specify that they wish to invoke the rule, or that they want backdating for a particular period, or that they wish to invoke a particular circumstance in Regulation 26.3. There is no duty cast on the claimants at all. The language of 26.2 and 3 is simply that of inquiry by the Secretary of State. The most that there is the language in the first phrase in 26.2. The phrase, where the claim for universal credit is not made within the time specified in paragraph 1. That, on its face, is very difficult to understand as a phrase, because 26.1, as we're all agreed, is an automatic deeming rule that provides for a particular date to be the date from which the period starts, and there is no time period within which you're making such a specification, and so nothing for the phrase to bite upon. It's the first indicator that this is a very unhappily drafted provision. The second indicator that it's a very unhappily drafted provision is the phrase, to the date on which the claim is made. Just read that in the context of the subparagraph. It makes no sense whatsoever. It would make sense if the word to was replaced with the word from, because then it would be the Secretary of State is to extend the time for claiming it, subject to a maximum extension of 1 month, from the date on which the claim is made, i.e. the Regulation 26.1 date, if the following conditions are met.
Is that right? I mean, if you make a claim on the 1st of February, and it is clear that you are actually claiming in respect of the 1st of January, or a period going back to the 1st of January, so your period starts on the 1st of January, what he's doing is he's saying your time for claiming for that period, which would normally be the 1st of January, is extended to the 1st of February, which is the date you actually put the claim in. So isn't too...
With respect,
right?
that's obviously the sensible way to read it, but it's not what it says, and it's particularly not what it says in the light of Regulation 10, which is the regulation at page page 72 of the authorities bundle. This is the provision that determines when the claim is in fact made. It was this provision that was being litigated out in the GDC case, because in GDC there was a debate about whether or not the claim was made when you'd opened your account and partially populated your form, had a few additional dates to materials to supply but hadn't yet pressed the word send, or whether or not it was only on the date that you pressed send. And what Regulation 10 does, as explained by the Upper Tribunal in GDC, is say that the date of claim is the date on which you press send on the form.
Yeah, I must say I just assumed that was the case. Anyway, now, unless you say you got only a few more words on your Proposition 6, we'll stop now. If you have got just a few more words on your Proposition 6, let's finish
No,
it.
there's a bit more to unpack on the actual construction of Regulation 26.2.
Yes, I'm sorry. I think I misunderstood your principles. I thought they were.
This is the entirety of my case.
Exactly, but yeah.
Are you going to go to section 9, or is that a?
Well, section 9, my lady, I am going to go to it. Yes, but we say once you understand the difference between the parties, is there or is there not a jurisdictional requirement?
Yeah.
It doesn't really add much.
Yeah.
Okay, 2 o'clock.